Hi folks, Steve Marlowe here from Marlowe Law Office, talking about Chapter 7 Bankruptcy. There are two types of bankruptcy protection available in the United States to consumer debtors. They're named after where they appear in the United States Code, which is our collection of national laws. That is Title 11, Chapter 7, and Chapter 13. First thing that we need to talk about under Chapter 7 is the means test. Assuming a debtor has passed the means test, that debtor can file a case under Chapter 7 of the Bankruptcy Code. A debtor needs to make, in the 6 months prior to the filing, less than the state's median household income for a family of like size. So if you're a family of 4, you need to make less than the average family of 4 in the state of Ohio in order to qualify for Chapter 7. Chapter 7 also, Chapter 7 cases now also require the debtors complete 2 trustee-approved debtor education classes, one prior to filing and one after the 341 meeting of creditors. In Chapter 7 cases, these classes are usually conducted online or over the phone and cover such matters as ledger keeping, budgeting, and living within one's means. Chapter 7 is essentially a financial reset button. In a Chapter 7 case, a person called a trustee is hired by the court to decide if it's possible to sell a debtor's assets and pay the resulting proceeds from that auction to unsecured creditors. Most Chapter 7 debtors have no assets to sell, and these cases are called no-asset cases. Once a trustee has evaluated the case and made distributions or declared a no-asset status, the debtor then receives a discharge from responsibility to pay any debts to any creditor. A lot of people question whether they have to go to court in a Chapter 7 bankruptcy. Chapter 7s require a meeting of creditors or a 341 meeting. This meeting fulfills the due process requirement of the Constitution by allowing creditors an opportunity to appear and be heard before the court or the trustee and before the court extinguishes their right to collect on debts. The trustee also questions the debtor as to the nature of his or her estate. Unsecured creditors like credit card companies rarely show up. It's just too expensive based in comparison to what you owe. The meetings often last less than 10 minutes. Do you get to keep your stuff? Well, yes. In Ohio, you're allowed certain things called exemptions, which an attorney will apply against any equity or value that you have in your possession. You're allowed to keep the first $20,000 of cash after a sale of your home, assuming that sale results in a positive result or equity. You're allowed to keep the first $3,225 of value in an automobile, $400 in cash, $20,000 or in the range of $20,000 of personal injury award, almost $11,000 of personal property, $1,350 of jewelry like wedding rings, and $2,025 in tools of trade. You're also allowed something called a wild card of $1,075, which you can sort of throw at any personal property you want. So if you have a great classic hi-fi from the 70s and you don't want to get rid of it, you can apply that exemption to your great classic antique hi-fi. What do you still have to pay? Well, if you owe child support or spousal support, you'll have to pay that. You'll have to pay most kinds of taxes, although some kinds of taxes are dischargeable. You'll have to pay any award for death or injury related to drunk driving. You'll have to pay almost every student loan that you've taken out, with some exceptions, or except in some circumstances. You'll have to pay criminal fines, penalties, and court costs, or any undischargeable debt from a prior bankruptcy case. So what are the next steps? If you're facing foreclosure, or if you're facing a garnishment, or if you just have questions about Chapter 7 bankruptcy, please call Marlowe Law Office for a free consultation. Our number is 937-506-0505. That's 937-506-0505. Or just click on the link at the bottom of your screen that says marlawoffice.com. Thanks.